name is Elisa. In this video, I'm going to explain what is customary international law and its importance. Let's start with the first part of the question. What is customary international law? As the name suggests, it is a source of law that originates from custom practiced by states, which later evolved into law that bind nations internationally. The history of customary international law could be traced back to as far as in the Middle Ages, when the English law established the law merchant and maritime customs began to be accepted as a universal application. But the central question to this is, how do such norms formulate into international law that bind all the states? This would have to be answered by looking back at how early writers in the 16th century viewed customs as a source of international law, as their theories form part of the basic concept on how customary international law stands today. If one looks at how norms were justified in the 16th century, there were two scholastic views. The naturalist view, adopted by Hugo Grotius, explains that states are bound by customs because there is a universal reason to do so. Therefore, the rights of states to make war and to punish violators of such principles are a result of universal application by the states. As time passed by, the paradigm shifted towards a positivist view in the 18th century. Vattel theorized that customary international law was created by tacit consent of states. Therefore, only states that chose to participate were bound by the customary law. However, his theory lost its authority by the end of the 19th century, as it failed to explain why certain states were still bound by the norms, although they did not express their will. For instance, the non-European countries, such as Turkey and Japan, were bound by European norms in international affairs. With the defects in Vattel's theory, a modern positivist view emerged in the early 20th century. W.E. Hall and Lasse Oppenheim developed a universal theory founded on the common consent of nations. This common consent approach is the reigning theory of customary international law today, binding new states without a consent or participation unless they have objected to the rule since the very beginning. The naturalist view and the positivist view are the traditional accounts that explain why nations comply with customary international law. Today, the authority that defines the essence of custom is found in Article 38 of the Statute of International Court of Justice. According to Article 38, and confirmed in the case of Libya or Malta continental shelf, in order that the custom formulates into a binding international law, there must be a state practice followed by general acceptance of that state practice, or what is called the opinio juris. State practice refers to the actual practice engaged in by the states. Evidence of state practice could be gathered through administrative acts, legislation, decisions by the local courts, or even through the United Nations General Assembly resolutions. In order to distinguish non-binding practices from binding customary law, the state practice must be one that is widespread and uniform. The key authority for uniformity was laid out in the asylum case, in which case the ICJ held that the custom of asylum in relation to unilateral qualification of the offense in question only applies in Latin America. Therefore, it was not uniform and thus insufficient to prove that custom was generally applicable. Similarly, in the Anglo-Norwegian fishery case, the ICJ dismissed the UK's claim of custom in defining the baseline for measuring territorial sea, as the practice by the states was not uniform. As the law requires a certain degree of uniformity, this poses the question on how uniformity should be measured. Although in the North Sea continental shelf cases, the ICJ remarked that state practice must be both extensive and virtually uniform, the court later in Nicaragua versus United States mentioned that it would be sufficient so long as the state practice is generally consistent. It does not need to be in absolute rigorous conformity with the customary rule. Having recognized that there is a widespread and uniform state practice does not transform a conventional norm into a customary rule. What renders a custom binding is the opinio juris of the states, which refers to the belief that states are under a legal obligation to carry out the customary rule. The requirement of opinio juris was confirmed in the Lotus case, in which the Permanent Court of Justice dismissed France's claim that Turkey had no jurisdiction to try their nationals because there was no belief that Turkey was legally obligated to abstain from instituting criminal proceedings based on the facts of the case. Since opinion juris is a normative ingredient, it is difficult to assess what states actually believe. The only possible way to have an indication of such beliefs is to look at what a state says it believes through statements, military manuals, and national case law. Through this practice, the belief of what is considered to be legally binding is transmitted. Customary international law is thus prima facie established when the requirements of state practice and opinion juris are met. But in order to secure the legitimacy of a customary rule, there must be consent from the states, and the theory of consent ties back to the modern positivist view that was explained earlier in this video. Under this theory, occurrences will be taken as silent consent from states, as affirmed in the case of Gulf of Maine maritime boundary. Therefore, all states are bound by customary international law since their independence. However, if states consistently object to the first formation of the customary rule, the objecting state may not be bound by the particular custom, as established by the persistent objector principle. It is important to note that there are certain customary international rules which cannot be objected by individual states, as they are so vital that such rules are elevated to jus cogens norms. Example includes prohibitions against torture, slavery, genocide, and human trafficking. This basically sums up what is customary international law. Traditionally, it was the naturalist and the positivist views that explained how customary law is binding on all states. With the enactment of the Statute of ICJ, customary international law is now defined as general consistent practice of states, followed by them from a sense of legal obligations. However, the long-held concept of state practice and opinion juris is being challenged by the 21st century modern scholars. Despite the challenge, it is to be reminded that Article 38 of the Statute of ICJ still remains an authority, and the arguments put forward by the modern scholars are only to explain the scope of customary international law and not to undermine the two-element concept. The modern scholars argue that state practice and opinion juris are not the only building blocks for customary international law. The jurisprudence of the International Criminal Tribunals has slowly begun to find its way into domestic law and customary international law. They also insist that signing of a convention or a treaty by many countries is evidence of the creation of a new customary legal norms. With the increase of national and international courts in identifying and applying customary human rights norms, we can see that customary international law is growing more important. This leads us to the second part of the video to appreciate the importance of customary international law. There are four main points of importance to be discussed. Firstly, customary international law plays a very crucial role in non-international armed conflict. This is because non-international armed conflicts are subject to fewer treaty rules than international armed conflicts. Treaty law covering non-international conflicts is fairly limited and mainly contained in the Common Article 3 of the 4 Geneva Conventions and Additional Protocol 2. As such, non-international armed conflicts are subject to limited protection regime. However, the International Committee of the Red Cross asserts that customary international humanitarian law applies to all conflicts, irrespective of the character of the conflict, whether international or internal conflict. This is particularly true with the rules on the conduct of hostilities. For example, while treaty law does not expressly forbid strike on civilian objects in non-international armed conflict, such restriction is protected under customary international law. Therefore, customary international law is said to have gone beyond existing treaty law and expanded the rules applicable to non-international armed conflicts. Secondly, customary international law is significant because it binds all the states. Contrary to treaties that only apply to parties that have ratified them, once a rule of customary international law has been established, it generally applies to all the states even if they have not formally consented to it. As a result, all states are particularly impacted by the creation of customary international law and thus forming the interest to participate in development of a customary law. For instance, Taiwan has not ratified the 1949 Geneva Conventions, but they are bound by the relevant customary humanitarian law in Common Article 3 of the Convention. Thus, they are subject to prosecution for violations of Common Article 3 prohibitions in regard to treatment of prisoners of war. The third importance is that treaties that have been codified into customary international law can bind non-signatories. For example, evidence of state practice confirms that some norms found in the Universal Declaration of Human Rights have become customary international law. This was demonstrated by the United States in two cases, one domestic case and one international case. In the hostages case before the ICJ, the United States argued that Iran had violated certain fundamental human rights of the hostages by infringing the Charter of the United Nations, Universal Declaration of Human Rights, and the International Covenant of Civil and Political Rights, ICCPR. The court held that Iran was acting unlawfully by wrongfully depriving human beings of their freedom, thus violating the conventions mentioned earlier. In the domestic case of Vilatiga versus Pina Irara, the United States had yet to ratify the ICCPR, hence the plaintiff could not rely upon it to seek for protection, but instead had to show that torture violated customary international law. The court ruled in favor of the United States and held that prohibition of torture had become part of customary international law. Thus, state practice as confirmed by judicial decisions affirmed that certain fundamental human rights have acquired the status of customary international law. Last but not least, customary international law is helpful in filling in the gaps in existing convention law. Due to the constantly evolving character of customary law, it can complement and facilitate treaty law when necessary. For example, when treaty rules are uncertain or ambiguous, customary international law can aid in the interpretation and further clarification of the treaty law. Such a role is more important when it comes to jus cogens, as they preempt over other norms with regards to rights and duties. With all these discussions focused on the role of customary international law, we can safely conclude that it is truly important. Not only does customary law play a vital role on international platform, it is also useful when it comes to domestic policies. For instance, domestic courts have routinely relied upon customary international law in cases concerning human rights norms rather than referring to general principles. This could be shown under Article 25 of the Basic Law of German Constitution, which provides that general rule of public international law shall be an integral part of the federal law. To conclude, customary international law is the second source of international law under Article 38 of the Statute ICJ. It develops as a result of state practice and opinion juris endorsed by other states. It remains very significant, and in fact, the Human Rights Committee like the International Court of Justice and the International Law Commission now recognizes the growing importance of customary international human rights law. That's all from my presentation. Thank you for watching.